Marijuana. We've all heard of it, we've all seen our favorite TV characters use it, and we all know what it does to you. What a lot of us don't know about the green leaf, however, are the laws that surround its use in Western Australia. This video will cover the basics of the laws around marijuana use and how they may apply to you. Because of popular culture and media, a lot of the thoughts around marijuana are that it's fun and rainbows and can help make you feel better. While marijuana is used because of these reasons for a range of questionable recreational purposes, there's also one big thing that marijuana is in Western Australia. That is, marijuana is very much illegal. Shocker, I know. Now, let's say you have a bit of a green thumb and you decide to grow some marijuana in your backyard instead of the normal, carrots and flowers. Unfortunately, according to the Misuse Drugs Act, it is illegal to possess, use, sell, supply, manufacture, prepare, or cultivate cannabis. This means that it's not only illegal to grow cannabis without a license, but it's also illegal to gift it to any of your friends. If you're found in possession of cannabis, some of the consequences in WA includes your wallet being at least $2,000 lighter and or 2 years in prison. If you're found to supply cannabis to others, you can get up to a whopping $100,000 fine and or 25 years in prison. If you're over the age of 14 and found with 10 grams or less of cannabis, according to the situation, you'll either be given a cannabis intervention requirement or a drug conviction. If you've been given a CIR, you will be required to book and complete a cannabis intervention session within 28 days of receiving the CIR. Alternatively, you could have the matter heard in court. But if you complete the CIS, you will not be required to appear in court and no further action will be taken for the alleged offense, including a criminal conviction. Now, you may be asking, let's say I do have a drug conviction on my record. How will this affect me in the long term? The answer is somewhat simple. Generally, convictions can be spent after a certain period of time. In regards to serious convictions, such as a drug offense, this time is usually 10 years, but it depends on the circumstance. While the conviction is on your record, however, it can cause difficulties in things like getting a job, applying for credit, or applying for visa to travel overseas. This especially applies to countries with strict drug laws. Surprisingly, not all cannabis is considered illegal. Before anyone gets too excited, there are very strict laws around this, and it's only for medicinal purposes. The term medicinal cannabis refers to legal, high-quality, standardized products made from crude or raw cannabis and can only be prescribed by a doctor if they believe it to be a suitable treatment option. It can only be obtained through a prescription from a doctor, which can be dispensed at any Western Australian pharmacy, but it usually comes in the form of a pill rather than something you can smoke. While we're on the topic of doctors, say you and your friend are at a party and everyone except for you is smoking a joint. While you're catching up on Wei Ling's crazy weekend, she suddenly gets dizzy and collapses in front of you. You frantically pull out your phone to call an ambulance, and your other friend Brittany stops you, saying that marijuana is illegal in WA, so doctors will have to report you guys to the police and you could be convicted. In this situation, it would be best to take Wei Ling to the doctor to seek treatment immediately. Doctors are subject to patient confidentiality, which means the only circumstances in which they're required to report the drug use is when the patient is a threat to the doctor's safety, if they're a threat to themselves, or if they're a threat to others. Back to the example, let's say that you get home from the hospital and remember Brittany telling you that marijuana is illegal. Even though you think yourself to be a law-abiding citizen and weren't smoking anything while you were with them, you begin to question whether or not you are a criminal now. Technically, you could be charged with a criminal offense. Now, this is because Section 11 of the Criminal Code Compilation Act states that aiding, abetting, counseling, or procuring the commission of an offense is in itself an offense. In this case, if you're aware that your friends are smoking marijuana and you're still around them, you could be charged with aiding the commission of the offense even without participating in it. As a consequence, depending on the situation, you could be charged under the Misuse of Drugs Act, assuming that you have knowledge and control of the drug in question. If you were unaware of the drug and had no control over it, and you were somehow able to prove it, you would likely not be charged. However, in this situation, because you were with your friends and you knew that they were smoking something, you were likely to be charged. All in all, unless you have a doctor's prescription for a condition, it is illegal to consume marijuana in Western Australia. Whether it's smoking it through a joint, eating it in a brownie, or consuming it as a health smoothie, manufacturing, supplying, and using marijuana is considered a serious offence in Western Australia and could lead to a criminal record for a very long time.